The right to claim alimony or maintenance is not absolute under Indian law. Most people hear this line and ignore it because they believe if the marriage fails, maintenance follows. But that is not true. Under Indian law, maintenance is not based on what you say. It is based on what you can prove. It is not based on separation. It is based on justified separation. If you cannot justify why you walked away, the law will not support you for walking away without any valid reason. Hello everyone, welcome to NRI Legal World. I'm Advocate Sonia Bhatti, a legal assistant at NRI Legal World. Today, we will understand the legal scenarios where the court can deny alimony or maintenance. Maintenance and alimony form a crucial part of matrimonial law. These provisions ensure that a financially dependent spouse is not left destitute after separation or divorce. Indian law clearly outlines circumstances under which a spouse may be denied maintenance. One of the most significant grounds is when a spouse chooses to live separately without any sufficient cause. Under Section 125, Clause 4 of the Code of Criminal Procedure, a wife is not entitled to claim maintenance if she refuses to live with her husband without any reasonable justification. A significant illustration is the case of Amit Kumar Kachhap versus Sangeeta Topo. In this case, the wife filed an application under Section 125 of the CRPC seeking maintenance from her estranged husband. The family court in Ranchi allowed her to claim maintenance and directed the husband to pay Rs 15,000 per month as maintenance. The husband challenged this order in Jharkhand High Court and contended that the wife left the matrimonial home without any valid reason. The wife alleged cruelty, neglect, and even extramarital affair of the husband. Upon examining, the High Court found that the wife failed to prove any valid reason for living separately and her allegations lacked evidentiary support. So the court concluded that the wife was living aloof from her husband without any reasonable cause and hence she is disentitled to claim maintenance. The maintenance order of granting Rs 15,000 per month was set aside by the court. This case was not just about one situation. It reflects a broader legal principle. The same reasoning applies in other situations as well. There are some other conditions also where maintenance is denied. If a spouse is living in continuous adultery, the foundation of maintenance claim gets affected, and a spouse is not entitled to claim maintenance in such cases. The second is mutual consent separation. If both parties agree to live apart, the element of neglect disappears. The right to claim maintenance in mutual consent separation only exists when both the parties agree on the same terms of maintenance. The third condition is if the spouse has sufficient sources of income or if the spouse is capable of earning, then the court may deny or reduce maintenance in such cases. The fourth condition is remarriage. The obligation to provide maintenance ceases upon remarriage, as per the Hindu Marriage Act 1955. And the last one is suppression of material facts. If a spouse conceals or misrepresents any facts, then it can lead to rejection of the maintenance claim. It is important to note that maintenance under the Hindu Marriage Act 1955 is gender neutral. However, a husband may be denied maintenance if he is capable of earning but chooses to remain unemployed, or if he has sufficient sources of income to sustain a healthy lifestyle. Indian matrimonial law strikes a careful balance between protection and prevention of misuse. Your case does not depend on your separation. It depends on your reason, your conduct, and your ability to prove it. Because in the eyes of Indian courts, maintenance is not granted because you walked away. It is granted only when you had no choice but to walk away. This video is for informational purposes only. It is advised to seek professional guidance before making any decision. You can contact NRI Legal World for any professional guidance. Thank you.